All right, welcome everyone. I am Melissa Skiffin. I am a disability and family support advocate at Achieva. Um, I have been at Achieva for 5.5 years, which is hard to believe. It feels like it was just yesterday. I am also the parent of a now teenager. My son turned 13 a couple of weeks ago. He has Down syndrome and autism, so I am a professional, but I am also a parent in this space as well. Looking forward to all of the information that Kelly is going to share with us tonight. Before I quickly go through my slides, just as an intro, I just want to share some of the Google controls. And if you've heard this before, I apologize, but Google is not used by a ton of people. So I want to make sure everyone knows where the controls are. If you go down to the taskbar on the bottom of your screen, the first icon to the left is your microphone. The next one is your video off and on. You are welcome to have your video on, video off, whatever you need to do to feel comfortable. I want everyone to feel at home and safe and comfortable in this space. So if you are comfortable with your camera on, that is fine. But if you want to turn it off, that is also fine too, whatever works for you. The next icon is the closed captioning button. You can use that, you can turn that on and off for yourself, but also when the video is recorded, closed captioning will be added to it for anyone that's viewing it after. The next is the fun button, that's the reaction. So if Kelly says something that you're a huge fan of, please feel free to hit the reactions button. You could also use the raised hand feature. Or if you go over to the far right on the taskbar on the bottom, the middle icon is the chat, and you're able to use the chat to communicate. And I'm also going to be dropping some links in the chat as Kelly's going throughout the presentation too. So I am going to be Kelly's wing person tonight. Kelly, I'll do my best to make sure that I am dropping those links in as quickly as possible. I have it pulled up, so I should be pretty good about getting them in there. But you guys can use the chat too, but like I said, I will stop the recording at the end if anybody wants to ask any questions and they don't want that to be recorded. So that is that on the Google Slides. I'm going to go through real quick and then I'm going to turn it over to Kelly because she has a lot of fantastic content to get through tonight, and I know it's important to all of us. So thank you guys for being here. Again, I am with Achieva. Achieva has been around for almost 71 years. I work in the advocacy and family supports, which is also under the ARC of Greater Pittsburgh and the ARC of Erie County, which is we are under the umbrella of the Achieva family of organizations. As advocates and family supports, we offer free technical assistance and individual advocacy to people with disabilities, their family, and the community. From early intervention, special education, transition to adulthood, government benefits, and home and community-based services. So we support people through the lifespan. We also engage in systemic advocacy issues at the state and federal level, and work to develop policy on disability and healthcare issues. So that's just kind of a very general overview of Achieva and the ARC of Greater Pittsburgh and ARC of Erie County. Here's our family tree, if you will, and I'll spare you going into all of the details, but like I said, we at Achieva do support people across the lifespan in various ways. The ARC of Erie County is one of the newest additions to the Achieva family of organizations, and so is the Autism Connection of Pennsylvania. Here is our geographic reach. We do support people in advocacy in Beaver, Erie, Allegheny, and Westmoreland County, but Achieva as a whole supports people across the Commonwealth in various ways. And then here's our mission and vision. And if you've heard me say this at previous webinars, I apologize, but we recently changed our mission statement to Achieva Advocates With. It used to be Achieva Advocates For, and I'm very excited that we changed it to With, because that is really what we want to be doing. We want to be advocating with people, which kind of goes hand in hand with this whole supported decision-making concept. So I wanted to make sure I shared that. And then our core values: respect, passion, ethics, change, and team. And last but not least, here's our contact information, which I will share in a follow-up email, probably early next week. So don't feel like you have to write it down, but I will share the slides, and let me stop sharing my slides. And while I do that, I'm going to bring up Kelly's slides. Kelly is here with us this evening, and we are super excited to have her. It is a great opportunity for all of us to learn from everything she's going to share with us. And Kelly, I'll let you do your own intro, but Kelly is with the Disability Rights of Pennsylvania. So Kelly, go ahead. The floor is yours, and I'm going to pull up your slides.
Okay, great. Thanks so much. I'm delighted to be here. Happy to do this presentation. Hopefully get to chat with all of you, maybe at the end if you have questions or comments. I look forward to that. I can talk a little bit about Disability Rights Pennsylvania, and while I'm doing that, if you want to, you don't have to, but if you would drop in the chat, if you are here as a self-advocate or a person with a disability, a parent, an advocate, or a professional, or however you want to categorize yourself. If some of you don't mind putting that in the chat, it just helps me to understand who's in the virtual room. And I can try to tailor things a little bit as we go along to who's here to hear. So I'm from Disability Rights Pennsylvania. If you're not familiar with our organization, we are the protection and advocacy organization for the state of Pennsylvania. The protection and advocacy organizations are what many people call the P&As. Were established by a series of federal laws dating back to the 1970s, going through to today. There is a protection and advocacy organization in every state and territory in the United States. So there's 57 in all. And we have the authority under federal law to provide protection and advocacy services to people with all kinds of disabilities. We do work across a variety of areas around unnecessary institutionalization, support and development of community-based services. We do legal work on all kinds of discrimination issues and enforcing of rights. We do a lot of education and outreach. And we do a lot of work around decision making and guardianship, which is what I'm here to talk with everybody about today. So the focus is going to be on supported decision making and also other types of alternatives to guardianship. And we'll talk a little bit about guardianship law as well and some exciting new developments in that area. So do you want to go to the next slide, Melissa? Great. One thing that I think is interesting to keep in mind is that the issue of decision making and guardianship and alternatives to guardianship, it's important for everybody, whether you're a person with a disability or not, or whether you're working with people with disabilities or not. Any one of us could come to a time in our lives where we need assistance in making decisions because of old age or an accident, perhaps. It could be temporary or long-term. So these are really important concepts to think about, and decisions for all of us to make about our own lives and decision making. So I always point that out to folks at the beginning, that this has a lot of universal application to folks. So until about 40 years ago, as many of you know, most people with disabilities were segregated in institutions, and they lived most of their lives in those settings, and they were wrongly presumed to lack capacity to take care of themselves, to make any kind of decisions at all. And so therefore, they weren't allowed to make any decisions. They did not practice the skill of making decisions. And one problem among many with institutionalization is that it can foster dependence on others, because you're basically in a setting where you're not required to do anything or make those kinds of decisions for yourself. And it really undermines, and we're going to talk a little bit later about the impact that that can have on a person to be in that situation. But today, we've come a long way from that. We've still got more progress to make. But certainly today, the integration of people with disabilities into the community is the norm. Most people with disabilities live in the community and they're not institutionalized. They don't live in institutions. And so the issue of decision making by people with disabilities, everyday decisions, financial decisions, healthcare decisions has become an issue that has gotten a lot of attention, right? And you're all here because you have questions about how this works and what are the best paths to take. So protecting the rights of people with disabilities who are living in the community now to be able to maintain their autonomy, to be able to make decisions for themselves is really critical. It's really a civil rights issue. It's a due process issue for people with disabilities. You can go to the next slide. So right now, adults, even adults with disabilities, kind of the default position, the assumption is that they have the right and the capacity to make their own decisions. And it's not until there's a legal determination to the contrary that that right is taken away. So all adults are presumed to have capacity to make decisions. And as I've said, the freedom to make decisions is fundamental to autonomy and self-determination. If we go to the next slide, you'll see a chart. This is actually from Achieva. I used to do this presentation many times with Nancy Murray, and she had this slide in her deck, which I really like. So I stole it in her honor for this one. This is really based on a lot of research and study that's been done on the issue of self-determination, and that people who live self-determined lives have the following positive outcomes. They're healthier, they're more integrated, independent, they have less feelings of hopelessness, inadequacy, and they're better able to recognize and resist abuse, which I think is such an important thing to note. That decision making is a skill that's more than just about making decisions. It really does help people to be robust members of the community. You can go on to the next slide. Okay, so what do we mean when we say that a person is able to make decisions? What does that actually mean? Um, So it basically breaks down to these two concepts, and they're a little bit legally in nature, but I think they also have a kind of a common everyday meaning as well. So we're going to talk about them a little bit. And those two terms are capacity and consent. So the issue is, you might hear people talk about this, does a person with a disability have the capacity to provide consent? And those words get thrown around a lot. So I thought we would talk a little bit about that. So first, consent. There are really two main areas of consent. The first is simple consent. And that's really talking about providing agreement or an okay for a decision on routine matters, like everyday decisions that we make and that we agree to on a matter that poses no risk of harm greater than is normally encountered in everyday life. So those would be things like, I'm going to decide where to go to eat dinner. I'm going to decide to go out and do grocery shopping today. I'm going to decide to go to the ATM and pull out $20. Those kinds of simple decisions that happen every day, that's just simple consent. Informed consent is different, and that those are for decisions where they have greater risks and consequences than those encountered in everyday life. So that would be things like, do I want to have elective surgery that a doctor is talking to me about? Do I want to take out a loan to buy a car or a house? Should I, quit my job to pursue another job? All of those things are probably would fall into the category of informed consent. Those are not the kinds of decisions that people make every day. They require, a higher level of consent, a more complex type of a consent to make those decisions. can go on to the next page. Okay, so now let's talk about capacity. Remember, I said the two words were a person has capacity to provide consent. So what does capacity mean? And this is really relevant to the law that we're talking about here around decision making. Its capacity means that a person possesses the ability to understand a situation, the options that are available, and the risks and benefits kind of associated with a decision, that they possess the ability to use that information to, in a kind of a rational way, they can apply the information that they have to the options that are available. And third, and this is important, and I think sometimes gets lost in the discussion about capacity, it's also the ability to communicate that decision. And it doesn't have to be verbal, obviously, just any way a person can communicate to somebody, on the outside about what that decision is. And it's the having those three attributes is what we mean when we say a person has capacity. So the very important thing that one of the important takeaways from this, I hope, is that you question anytime anybody says, does this person have capacity to give consent? Um, and or does this person generally have capacity? And the question that I think we all have to ask is capacity for what? Consent to do what? Because a person, many people with disabilities have varying kinds of levels of capacity. You might have capacity in some situations for some types of decisions and maybe not in others. And so it's very critical that you ask capacity for what? A person, any of us are not, universally able to make a decision or not in all scenarios. It's not like capacity is like a monolith. It changes, it depends on the situations. And so it's very important that we think about those two words as they interplay with each other, consent and capacity, and we're really looking at the context. The other thing to note about capacity is that it doesn't, you're not required to always make good decisions. Sometimes people who have capacity to make even very complex decisions, to give informed consent, sometimes those people make really bad decisions. I always say I could list for you, if this was not being recorded, all of the really bad decisions that I've made in my life. And I probably am considered to have capacity for those decisions, right? So whether or not you agree with a decision or you think a decision is good or not good, that's really not relevant to the analysis of whether or not somebody has capacity to make decisions. So we can go on to the next slide. All right. So what if either you or somebody that is in your family or that you're working with um, really doesn't have capacity to make certain decisions? Maybe they really struggle in a lot of areas. Maybe it's just in the more complex decision making where informed consent is required. What happens in those situations? And I hope it's getting better these days, but certainly for a very long time, people just assumed that if that were the case for a person with a disability, that a guardianship is the way to go, and that guardianship would be required for a person in a situation where maybe they're lack capacity for certain decisions or they're not able to make the best decisions. People will think, oh, we should try to get guardianship for this person. This is a spoiler alert. There's going to be probably several of these as we go along. The answer to that is that guardianship is really rarely ever necessary in order to navigate the world of decision making, even for a person with a disability who lacks capacity to make some of the kinds of decisions that we've been talking about. So we're really going to get into that and the details and kind of how does that work and what you can do to help prepare for that. So that's what's to come. So let's talk about substitute and supported decision making. And I do think it's important to talk about the difference between those two. I think a lot of times we lump those two things together, which is fine. These are all tools that can be used to help to support a person with a disability and avoid having to put the person under guardianship. But there are different kinds, substitute versus supported. And so first, for substitute decision making, um, guardianship is one form of substitute decision making, but there are other forms that you may have heard of, like powers of attorney, representative payees, trustees, healthcare agents, advanced directives. We're going to talk about some of those things to come, but those are all forms of substitute decision making. And essentially what that means is that there's somebody else in a particular context who has been given the authority to make a decision for the person with a disability. So the decision is not being made by the person, it's being made for them, right? So those are substitute decision-making tools. Some of them are very, very good. Some of them are helpful to address situations. They're easy to implement, and short of guardianship, they do try to preserve as much of the person's rights as possible, right? So substitute decision making is the first category. The second category is supported decision making. And as I described, substitute decision making really does take away the ultimate decision making authority from the person with a disability. So there is a lot of advocacy around Pennsylvania and across the country to get people to learn about and start to practice supported decision making. And that is a process whereby the person with a disability still has the ability to make the decision. The decision is ultimately theirs to make, but they're just provided a system of support around them to help to enable them to make those decisions. So obviously that's the ideal, right, that we want to try to implement for everybody, regardless of capacity, to make various decisions to basically have people around a team who can help the person to make those decisions themselves. So let's keep going. We're going to break some of this down. I know Melissa said that we're going to turn off the recording, and we're going to be able to ask questions at the end. But if you don't mind being recorded, I'm happy to answer your questions if you want to raise your hand and you don't mind it being recorded, or if you want to drop it in the chat. I always feel like it may be easier to get through all of this to not have to hear me talk for an hour and a half before we get to questions. So I'm happy to do that if you have them in context as we go along. Some of this stuff is a little complicated, it's a little detailed. I'm trying to make it as simple as possible, but if you have questions, please feel free to just ask, and I'm happy to try to answer as best as I can as we go along. Okay, so let's talk some more about supported decision making. So basically, the idea of supported decision making rests on the idea that really all of us, regardless of whether we have a disability or the kind of disability that we have, face decisions in our lives that we struggle with, especially important decisions, right? Like some of those informed consent decisions that I talked about, like whether to switch jobs or to have surgery or to move to another city or something like that. And it's most of us, I know I certainly do, turn to family and friends. You might turn to professionals to seek advice, to talk through scenarios with other people, to enable ourselves to make decisions. And we certainly don't feel like we've lost autonomy when we do that. It's still our decision ultimately to make, but it sure does help to be able to talk with other people about those decisions. I often say I still call my mom to talk through important things. in my life and get her counsel before I decide, right? I think a lot of people do that with various people in their lives. And it's certainly no different for people with disabilities. And we really, in some ways, shouldn't think about it in a different way than that. At the base, that's what supported decision making is. It's just an extension of the common everyday decision making that we all use. And so in the context of a person with disabilities, where we're really kind of calling this out by name, this thing that we all do every day in our lives, um, this thing that we call out as supported decision making, it really can be formal or informal. If you're doing this with a person with a disability, there's not a single model out there for supported decision making. There are lots of different kinds of models that are being implemented across the country, trying different ways with formal agreements. There are some states that have legislation that they've passed that's kind of defined what supported decision making is. There's like a lot of discussion about whether that's the right way to go or if it's better to just leave it informal. So there's really no consensus on the right way to do it. But certainly there are certain elements that need to be present. And the first is you need to have a network of people, and it could be just one person or two, it could be a more complex network of folks that are around that have a trusting relationship with the individual, that they are committed to the process of supporting the individual to make decisions. The trust that the person has with this network of people is really critical, right? Because it's just like we pick people to talk to that we trust, right? And so it's the same thing with people with disabilities. If it's just a stranger, that person is really not going to be able to rely on that network in order to help with decision making. And the group of people that are around the person with a disability, sometimes it's called a circle of support or a team. Sometimes people refer to it as natural supports, whatever you want to call it. Those folks, one of the jobs that they have is to provide information to the person with a disability, to be able to understand options, risks and benefits, the consequences of decisions, that kind of thing. It's their responsibility to help gather that information and provide it to the person with a disability in a way that that person can understand. So in order to do that, that might also require the network of people to provide some accommodations to the person with a disability. You might need to present the information that is going into the decision making in plain language. You might need to make other accommodations in terms of the way that you're communicating with the person with a disability. You might need to give extra time in order for a person to process all of that information, in order to process the different elements of the disability, just all the kinds of accommodations that you might make for someone with cognitive or intellectual disabilities, you would want to do in this process of supported decision making as well. It's important to remember, like we talked about in the prior slide, that in supported decision making, ultimately it's the person with a disability who's the decision maker. And I think it doesn't mean that you can't say, hey, this is what I think, because I think that's what we all do, right? When we consult our friends and families and professionals, they're going to give, you their 2 cents about what they think you should do. But ultimately, at the end of the day, it's your decision to make. And that's important to maintain that in the context of supported decision making. I see a question in the chat about guardianship being dissolved after it's granted, and the short answer is yes. And we're going to talk about guardianship kind of all the way at the end. So I'm happy to talk more about that and help to answer your questions then. Okay, I think we can go to the next slide.
Kelly, I don't know if you want to answer it now or if it'll be answered later, but a second question just came in to the chat. Do you want me to read it or can you see it?
I can see it, yeah.
Okay.
Yeah, there's a process, you don't have to go through guardianship, the whole proceeding again, but you do need to transfer it from one court to the next. And I'm not really sure, to be honest with you, what that process looks like, but I don't think it's overly complicated to be able to do that. But you're not going to need, the guardianship should apply throughout Pennsylvania, so you're not going to need to go through the proceeding again to establish guardianship. Okay, so let's talk a little bit more about supported decision making in Pennsylvania in particular. As I kind of mentioned in the prior slide, we don't have law in Pennsylvania that specifically recognizes supported decision making. Again, there's nothing illegal about it, right? Because it's just like the stuff that we all do when we make decisions. We consult, we gather information, we talk to other people, we mull it over. Sometimes we change our minds. Sometimes we make bad decisions. There's nothing illegal about any of that. It's just that unlike some other states that have actually kind of passed law in the state that kind of spells out, this is what supported decision making is, and this is what, how it'll be recognized. We don't have that, not officially in Pennsylvania. That being said, it occurs all the time, and there are some things in the way that we do things in Pennsylvania that kind of recognize supported decision making without actually calling it supported decision making. So I'll talk about that really briefly. The first is in the context of guardianship. So we do have a law in Pennsylvania about guardianship, and we're going to talk more about that at the end, like I said. But the main standard for whether or not a person should be under a guardianship is the question of, do they have capacity? Yes or no. And the second part is, do they need to have a guardianship? So even if they don't have capacity, they still might not have a guardian entered if it's not necessary. And one of the things that the court looks at is the presence of a support system for the person. Do they have people around them, friends, family, or others who are able to provide support to them to help them to do these things that they need to do in their life? That's one of the things that the courts, specifically in the guardianship law, it says that the court should look at that. The court also is required to look at whether there are other types of decision-making tools that are available that could be helpful. And those are some of the substitute decision-making tools that we're going to talk about as well. So both supported decision-making and substitute decision-making are baked into guardianship law. And they're actually, if those things are present and being used and successful for a person, then a guardianship order should not be entered for a person. So that's one way the supported decision-making is kind of present and legitimized in Pennsylvania. Another way is that our disability services systems across Pennsylvania, so the intellectual disability services and other services that are available for people, definitely recognize the concept of natural supports. And if you have familiarity with Medicaid waivers and ISP meetings, you'll know that the concept of natural supports is definitely recognized there. And there's really a circle of support that's supposed to be participating in the ISP meetings for a person, helping to do the planning, and the person with a disability is involved in that, as well as other people in their lives. And that's really like a form of supported decision making. That certainly could be a mechanism for people to engage in the practice of supported decision making. If you're really looking to do this, if you're really looking to learn more about how this can be possible, I think that's one place to start. And then finally, like we've been talking about, it's recognized in Pennsylvania to the extent that we all do it, right? And there's nothing wrong with it. There's nothing that stops us. It does not make a decision that we make less legitimate because we engage in supported decision making in order to do it. Okay, we can go on to the next. One last slide, and this again, this is one I stole from Chiva and Nancy Murray from our slides. She always had really colorful, nice slides, so they're nice to add in. But this is just to drive this point home one more time about supported decision making. That it's empowering persons with disabilities with the help of supporters to make choices, understand and explore the options, know the risks and benefits, get guidance and recommendations, make and communicate a choice, and carry out that choice if help is needed to do so. And again, isn't this how all of us make decisions, particularly more complicated decisions? So it's just to use that same model to help people with disabilities who are in your lives be able to make the decisions that they need to make. And to keep in mind that this process, going back to the self-determination chart that we saw, this process of exercising this decision-making muscle is really a positive force for a person to feel like they're empowered, to practice doing this, to feel like they have agency over their own lives, and some autonomy really has great benefits to the person with a disability in your life. Okay, we can keep going. Thank you. Oh, and Melissa just put in the chat right on time, and I missed it. 2 resources if you're interested in learning more about supported decision making. These 2 links are, I think, 2 of the places that are doing just really stellar work on supported decision making across the country. They have lots of resources there in these websites that will take you to other places and other resources. So it's a really great place to go if you want to gather more information about what people are doing all across the country to really move towards supported decision making where people retain their rights and ability to control their own lives. So thank you, Melissa. That was great. The resources are there. We're going to move on a little bit from supported decision making because there are limits on it, and I would be doing you all a disservice if I didn't talk about this. There are some limits on supported decision making, and so it's good to talk about what we can do beyond that to, again, maintain as much autonomy as possible for people with disabilities. So it's not going to be effective if the person with a disability doesn't want to participate, like doesn't want to receive help and support from a network of people, then that certainly is going to be a problem if that person doesn't have capacity themselves to make the decision. And not only that, maybe they do have capacity, maybe they don't have capacity, but if they're perceived not to have capacity to make the decision, that's an important thing to keep in mind, that if their decisions are not being accepted by people in the outside world, then that can be a problem, right? So the person doesn't want assistance. Supported decision making is not really going to be effective if there's already a substitute decision maker, such as a guardian or a power of attorney, with authority to act for that particular decision. So again, we have to ask capacity to do what. So it may be that there is a substitute decision maker for some things, but not all things. And then you could have supported decision making for the decisions that the person still has control over. But that's one thing to consider. The last one, we're going to talk more about these 2 categories because these are the ones that come up again and again. Supported decision making may not work if it's the kind of decision where it requires informed consent and the person that needs to receive that decision is not going to accept it from the person with a disability themselves. And so those would be some healthcare decisions that require informed consent, like, for example, engaging in elective surgery or, pursuing some kind of experimental treatment for something. And then some kinds of financial decisions. A bank may not accept the result of supported decision making for a large transaction, for example. They might want to have something else before they'll accept that. So let's keep moving and we can talk about what that looks like. So first, we're going to talk about healthcare decisions. These are the questions, right, that are on everybody's mind. What if I need someone to make my healthcare decisions for me? I'm a person with a disability and I really can't. I don't have the capacity to do that. Maybe I can't even really do it right now with the help of supported decision making. What if my healthcare decision that I make is challenged by the doctor? And again, here's the spoiler. I told you that I would repeat several times. The guardianship is not necessary, not even in this situation. And I'm going to explain. Trust me, I'm going to explain why. It's actually pretty easy. You have many options. So let's talk about healthcare decision supports. So here are some things that you can prepare to do ahead of time, if possible. So these are things that you can do to get ready. You can help a person with a disability get ready before they're kind of at the point where, a procedure is needed, the doctor is not accepting the decision, right? And then you're kind of in a crisis place. So here are some things that you can do ahead of time to plan. And it is really important that if you can do that, that you do prepare. And so for the folks that are on this presentation, this is great. This is a step towards that understanding kind of what the options are and to start that planning process. So we're going to talk about these briefly. Different kinds of healthcare decision supports. The first are advanced directives, or what sometimes are called living wills. The second are powers of attorney, where you would designate someone to be a healthcare agent for the person with a disability. And then third is you can designate someone to be a healthcare representative, which is different than a power of attorney. We're going to talk about that in a minute. And the thing to remember, I'll go through this and reinforce this again. Even if you don't take these steps, even if you don't prepare in advance, if you don't designate a healthcare representative, you don't sign a power of attorney, even if you don't do that, a healthcare representative is always going to be available to help make decisions for a person who lacks capacity at the time to make healthcare decisions. So we're going to talk more about that. You can go on to the next slide. Okay, so talk a little more about substitute healthcare decision making, and this is healthcare advance directives. So these are really preferable, and they do kind of exactly what the name suggests, which is it allows a person to set out in advance kind of what their wishes or preferences are ahead of time, so that when something happens down the road and they don't have capacity to make the decision or to communicate the decision themselves at that time, the healthcare advance directive is there to really make sure that that person's preferences and decisions are carried out. So that's a really great tool to use. Often they're in two different forms. Living wills generally are used for end stage, like if you have a medical disease or you're unconscious and it's the end of life, that would be a living will, which would set out ahead of time instructions that you want to have carried out on your behalf. The second form is a healthcare power of attorney, and that's probably one that more people are familiar with. That's not for end of life decisions. That's just for any kind of healthcare decision. And the idea is that if you can now designate a person to be your power of attorney in the event that at some point down the road you're not competent to make a decision, or perhaps a doctor says, I don't think this person can make this decision, they can't give informed consent, then you would have a power of attorney there for healthcare decisions who could make those decisions in your place. And sometimes those two concepts, living wills and power of attorney, are combined together in one document. So you have kind of the wishes of how the person wants the end of their life to go, as well as a power of attorney with certain jobs um, to carry out for healthcare beyond end of life. Okay, so we can keep going to the next slide.
Kelly, there was a question that came in the chat.
Mhm.
Did you want to wait on that? It's okay. I just want to make
Um,
sure you saw it.
yeah. Yeah, and that's a really great question, and I think that the answer is that it probably so let me repeat it so that if people can't see the chat. Are these advanced healthcare directives only applicable in the state they are established? For example, if one of those directives is established in PA, but the patient is in an accident and is being treated in a different state, will these directives be taken into account? It's a really hard question to answer because it may depend on the law of the state where you're in. If there was some reason that the particular tool that you had developed here in Pennsylvania wasn't applicable there. But overall, I think most states have these same basic kinds of tools, certainly powers of attorney, advanced directives. They have equivalents of those so that there shouldn't be a problem for them to be recognized. The real trick to this, I will, which I'm sure you guys have probably encountered this. It's not like there's a place that you can go like with the state and say, is this my legal document, right? It's more about in the context of you go into a particular hospital with a particular document, and that hospital or the doctor, or the attending physician or whatever calls into question whatever is in front of them, right? And that's really where these things come up. And I really understand that does happen, but that can happen, that happens sometimes even in Pennsylvania when you have the documents in Pennsylvania and you go to the doctor, sometimes that happens. I will say that we take a lot of calls at Disability Rights on those situations, and we've often intervened, called the hospital, and we usually almost without fail can get it worked out once we kind of get people online and figure out what it is, and then they'll accept the document. So, but I appreciate that that can be, an issue that comes up, I think, in other states for sure. Um, yeah, so there's, can you appoint a power of attorney for physical and mental health in the same document? Do you need a separate mental health care agent and paperwork? So I'm going to hold on to that. That's a great question. We're going to talk about that in just a second because we're going to talk about mental health um, care advanced directives. I think the important thing to remember is I think it could be in the same document as long as you're clear and have the right wording and all the requirements for each of those things, because there is no such thing as like a universal power of attorney. You may hear that. We hear that sometimes. People will say, well, I have power of attorney over this person. And there really is no such thing as like a general power of attorney. There's financial, there's healthcare, um, there's mental health, and there might be some others, certain areas, but they're specific, right? And there are different rules that apply to different types. So you just have to be very careful. And I think if anybody says to you, oh, I can make decisions for this person because I have a power of attorney, I would suggest that you ask to see it so that you can kind of tell, what the scope of it is. Does this cover finances? Does this cover healthcare? Does this cover mental health care? etc.? Are there stated interests and instructions from the person in the document? All those kinds of things are important to look at. So I think you could have it in the same, but you'd have to make sure that you were, checking all the boxes that you needed in order to, be a legally binding document. Okay, so let's talk about who can make a healthcare advance directive. So any adult age 18 or older who has the capacity at the time to execute a healthcare directive. So again, it's capacity to do what? So they have to be at least 18, and they have to have the capacity to understand that they are filling out an advanced healthcare directive. So for a power of attorney, for example, a person would have to have the capacity to understand that they would like person X, my sister, my dad, whoever that might be, to be my power of attorney for healthcare decisions, right? And so as long as the person can understand that that is what they're doing and that's the effect of them signing the document and that they're agreeing to that, then a person with a disability, a person with cognitive disability, intellectual disability, autism, etc., can execute an advanced healthcare directive, right? If they have capacity. If a person doesn't have capacity to make that kind of decision, then they really can't do a power of attorney. And that's one thing that we see sometimes where people will say, well, if a person with a disability doesn't have capacity, just have them sign a power of attorney. And that's legally not correct, right? Because if the person doesn't have capacity, they can't do a power of attorney. So that's not always a fix if a person's capacity is being questioned. It really has to be done at a point in time where you have capacity to enter into those documents. That's one thing for all of us to think about, which is that we all should think about these questions and fill out these documents for ourselves, for everybody, right, at the time that you can understand and do it. So in the event that you don't have capacity later, like these things are taken care of and your wishes can be carried out. But certainly this is a tool for at least some people with disabilities, because again, they don't have to have the capacity to make those complicated medical decisions. They just have to have the capacity to assign someone to be their decision maker for that. So that's something that with some support, a lot of people with disabilities are going to be able to do that. Melissa put into the chat a link to a sample advanced healthcare directive. This one is not from Disability Rights Pennsylvania, but from UPMC, but we thought it was a pretty good form, pretty easy to fill out. And certainly if you go to UMPC providers, they should be willing to accept their advanced healthcare directive on their form. So that could be a good helpful resource for people. I know that a lot of times some of this stuff is pretty complicated, trying to go slow and break it down. But I think for sure, for people to see forms whenever we have them, I think is helpful for people. There's a question from Sharon. Sometimes the person with the power of attorney mistakenly believes that it prevents the individual from acting on their own. That's a guardianship right. That's a great question. I think that happens a lot. I think a lot of people kind of confuse power of attorney and guardianship together. And they are two separate things, right? You could have a power of attorney, but powers of attorney don't go into effect until the person is incapacitated or is incompetent, right? A lot of places use those two words interchangeably, right? So I could enter into tonight a power of attorney and give Melissa the power to make healthcare decisions for me if I become incapacitated. But so then I have that and I sign it and I give it to Melissa, but Melissa can't exercise decision-making authority over me right now because I still have capacity. So that's another thing to keep in mind there, right? Is not only is it the power of attorney limited in scope in what you can control, right? I've only given Melissa power over healthcare decisions for me if I'm incapacitated, right? So Melissa can't do that now and never can make decisions about what I eat for dinner or where I live or how I spend my money, even if I'm incapacitated, right? That's why it's so important when you do powers of attorney to make sure that you're doing, specifying the type of power of attorney that it is, that you ask to see it so that you can, make sure that you know what it is and what it covers. So, so Joe asked the question, would that then be a durable power of attorney when it goes into effect in the event you're incapacitated in the future? That's correct. The one thing about all powers of attorney, though, if I've given my power of attorney to Melissa, that will go into effect when I'm incapacitated, I can revoke that power of attorney anytime up to the point that I become incapacitated. I can revoke it, I can change it, I can amend it, I could make somebody else the agent. Um, so yeah, so it's durable, but it's not like it's permanent, right? It can always be changed by the person who's entering into the power of attorney. Those are great questions. You guys are keeping me on my toes um, in this evening hour, right? Um, okay, I think we can go on to the next slide. I don't see any more questions right now. You guys have the link if you want to look at that. So let's talk about mental health advanced directives. This is really similar in terms of some of the rules to the general healthcare advanced directives. We just like to always talk about this because there are some differences here, and this is a tool that's very helpful really for a lot of people with a lot of different kinds of disabilities, all of us in our lives, where there could be issues where we have mental health issues in the future. It's the ability to set out in advance how you want treatment to go around medication, things along those lines. There are certain types of decisions that you can't include in a mental health advance directive, like it will not prevent a person from being what we call 302'd or committed involuntarily, but it can help with a lot of things, certainly after the person is committed in terms of the kind of treatment that they receive or don't receive. Having a mental health advance directive can help with that. So again, the rules are similar. A person must be 18 years old. They have to have capacity to make it at the time that it's signed. They can't be under guardianship, right? Or another type of substitute decision making when they enter into this document. They can't currently be involuntarily committed, right? You can't sign one once you've been committed. They're generally valid for 2 years. There are some exceptions. They can be revoked, just like the other types of advance directives. And they come in the same form. You can have a mental health declaration, which is kind of like the living will, where you just set out what your preferences are. Or you can have a mental health power of attorney, where you appoint someone to be your decision maker in the event that you're incapacitated and need mental health care. Or you can have a document that combines those two things together. There are requirements under state law for mental health advance directives. Melissa just put in the chat a link to information from our website, more about mental health advance directives, if you're interested and want to learn more about that. On any of these things, if you have personal situations for yourself or your family or a client or whatever it is, and you want to talk through those, and we don't get to do that tonight, or you'd rather not do it tonight, you can always call Disability Rights Pennsylvania and go through our intake system, and we will hook you up with one of our attorneys who can help to kind of talk through these things, kind of break it down a little more, go over things again, point you to resources and things like that. We can keep going. I want to check how I'm doing on time. Okay, got to get going. Okay, here's the good stuff. So this is my favorite part. So back to healthcare decision making. Going to talk about healthcare representatives. So let's say you don't have a power of attorney, you don't have an advance directive, you either the person doesn't have capacity to ever sign one of those documents, or you pulled up the link in the forum and you just never got it filled out, or whatever it is, right? That's life. These things, sometimes it's not pleasant to think about all this stuff, right? And we push it off to the side. So you don't have a POA, you don't have an advance directive, no problem. There is, in Pennsylvania, another tool that is so great that you can use for decision making for people with disabilities or people who lack capacity. And it is under a law that was passed in the early 2000s called Act 169, and it established what's called healthcare representatives. So a healthcare representative can make decisions for a person if a doctor determines that they're not competent to make a healthcare decision. So that's that scenario where you're in there and you're ready to, you want to do surgery or you want to have some procedure, and the doctor says, I don't think this person can make their own healthcare decisions. And maybe you push back and say, yes, yes, I can, or here's my team around me who's helping me make this decision. And the doctor says, no way, I'm not buying it. I'm not going to move forward with this procedure or this process until we have a decision maker. So you can use Act 169. The person has to be 18 years old, and it's for people that don't already have a guardian or a healthcare agent under advance directive already. So this is the situation where you don't have any of those things and you're in there and you need to try to move forward. So we can move on to the next slide. So there's two ways that you can take advantage of this law and use healthcare representatives. The first is you can figure it out in advance, and you can do a designation in writing, or just tell your health system, your family doctor, your surgeon, your provider, whoever it is, where you think this might be needed. You can just tell them and put it in your chart that your healthcare representative is your dad or your uncle or your brother, whoever it is. So you do a designation. And secondly, if there is nothing in writing, there's no designation, a healthcare representative is automatically appointed in the following order of priority. So the doctor says, I don't think this person has capacity to make this decision and give informed consent for this complicated procedure with risks and et cetera. And so there's no guardian, there's no power of attorney, there's no advance directive. A healthcare representative is automatically going to be able to be the decision maker in the order on this list. So first, it's the person's spouse or adult children who are not children of the spouse. Then next would be adult children, then a parent, then an adult sibling, an adult grandchild, and then finally, the catch-all, just any adult with knowledge of the individual's preferences and values, including religious or moral beliefs. So anybody that knows the person and knows like what they, would like to do, and knows what they like or don't like, can be appointed the healthcare representative and be the decision maker that then the doctor can rely on under state law as the decision maker in that situation. So two ways to go. You're covered either way. There's not a healthcare situation in which you won't be able to use healthcare representatives if you need it in order to proceed with healthcare decisions. Melissa put into the chat healthcare representative declaration, which is a fillable form from our website. And that is if you talk about this and make decisions ahead of time with the person with a disability about who is going to be the designated person who's the healthcare representative. It's a declaration that can be provided to the healthcare provider. Doctors and hospitals can ask for this kind of declaration. You know, they want to cover themselves and have in writing who the healthcare representative is. So you can fill out this declaration ahead of time, and that helps you to be prepared and present it to the doctor. There's some requirements in the state law of what needs to be in the declaration, and so it's there in that form. So it's easy. It's basically just information about you and the person and kind of where you fall on this list of priority. And so that's a great resource to check out if this is something that you're interested in kind of looking at and addressing ahead of time. We can keep moving forward. Okay, let's talk about financial decisions. Same kind of scenario. You know, you're a person with a disability and you really struggle with some financial decisions like managing money and making decisions is not particularly easy. Maybe you have some supported decision making and a team around you to help with those things. But maybe you're still not really able to make decisions for yourself, or perhaps you feel like you can and you've been working with your circle of support to make decisions, but then you run into somebody at a bank that says, I'm not going to approve that transaction for you. I'm not going to give you a loan, or I'm not going to allow you to do this or that because I don't believe that you have capacity to make those decisions. So again, the takeaway theme for the evening is that guardianship is not necessary. That certainly shouldn't be the first place that you go and think in terms of money management. So let's talk about some of the tools that are available in Pennsylvania for financial decision supports. So again, a couple of things that you can do now, kind of before you face that mean banker who won't let you proceed. You can think about doing a financial power of attorney. And that certainly a situation where a person with a disability is giving over decision-making rights to an agent, but if they can kind of designate who that is at the front end, they can describe the power and what the person is able to do. You can use a financial power of attorney in order to do that. You can apply for a representative payee for Social Security benefits. Many people with disabilities have that as a source of income or maybe their only source of income. A couple of other things that you can do to protect your benefits and to help with financial management are able accounts and trusts. And if we move forward, we're going to touch very briefly on some of these financial decision-making tools. Okay, representative payees. People are probably pretty familiar with this, but essentially anybody who's receiving Social Security, either SSI or SSDI benefits can apply to have a representative payee, and that person is just responsible for helping the person who is a beneficiary to manage their money. And you can apply, you can have somebody that the person knows be the rep payee. Sometimes it's a family member. If there's not anybody available, it can be someone from an agency who can be. There are some social service agencies that provide rep payee services, and it can be one of those that's designated as the rep payee. A person does not have to be um, found to be incapacitated. There doesn't need to be a guardianship or anything like that. It can just be based on whatever's in the application around disability and the need for assistance in managing benefits. And a rep payee, all of this is regulated by federal law in terms of what the rep payee must do. They have to make sure to pay for the individual's current needs in terms of housing, food, healthcare, personal, the things, the bills basically that a person has. Make sure that those are paid on time out of the person's benefits. Second, after those bills are paid or any past due bills are paid, they are to provide spending money, extra cash to the person with a disability to allow them to have some autonomy over their money. It might not be a lot depending on what the bills are and what the benefits are and how much money the person has available, but it does provide some autonomy to people to be able to spend some money on, things that they want to buy or that they want to do. And then third, the responsibility is to save any funds after those expenses are paid for the individual. We can go on to the next slide. So I kind of talked about this already about who can be the rep payee for a person. And then there is a process for removing a representative payee if there are problems or concerns regarding the representative payee. There's a process to file a complaint. You can ask for the person to be removed or for a new representative payee to be appointed. I think it's fairly easy to do that if there are any problems at all that a person can switch out who the rep payee is. I think it takes a little bit of time, not a ton, but a little bit of time for it to be moved from one payee to the next. Paul, I see in the chat says, does somebody have to be certified? And no, there's really not a certification process. There is a process for representative payees to be reviewed periodically. So actually, the Protection and Advocacy Organization, so my office does representative payee reviews in Pennsylvania. So we get a list of payees across Pennsylvania that we then go out and do, review bookwork and financial statements, and we talk to the beneficiary and we talk to the payee and all of that to make sure that there isn't fraud and neglect and that the money is being spent appropriately. So there are some safeguards in that way as well baked into it. You can file a complaint about a payee if you know there are problems. Anybody can do that, and sometimes we're given extra reviews to do based on those complaints. We can keep going. So I'm not going to talk a lot about these because we're getting short on time, but other options that are available to think about around substitute financial decision making, ABLE accounts, financial powers of attorney, and trusts. And for all of these things, I would say it's really good to go talk to experts about these things to make sure um, the PA ABLE website has great information about how to use ABLE accounts to save money for people with disabilities. And there's a process for an ABLE account where a person can have a fiduciary manage the account. So that's kind of a way of having supported help with financial decisions by using that in an ABLE account. Powers of attorney we've talked about. And then trusts, which are complicated, and you really want to talk to a lawyer or an organization like Achieve a Family Trust, who we talk to all the time at DRP because we're not really experts on trusts. They're a great resource to go to talk about the right kind of trust for a person with a disability and how to preserve the person's eligibility for benefits. So it's very important that you consult with experts for those kinds of things. We can keep going. Okay. So let's talk about guardianship. You'll see I leave guardianship till last because guardianship should be rare and the last resort. It's really not necessary for, I think, most people with disabilities. Most situations should be able to use the tools that we've talked about tonight to either support or help to make decisions for people with disabilities. It really is restrictive. kind of substitute decision making really limits people's autonomy, because the scope of what a guardian can do in terms of decision making is potentially very broad, depending on the order that is entered. We talked about this a little bit already. Should be the last resort. Even guardianship law itself talks about people that don't have capacity to make decisions should still be able to participate as fully as possible in decision making, and that really that guardianship should not be used if there are least restrictive alternatives that are available. And those are the kinds of things that we've talked about tonight. Next slide. So guardianship law in Pennsylvania, advocates, maybe some folks on this call, have been advocating for at least 10 years, maybe more, for there to be changes to Pennsylvania's guardianship law. The last time it had major amendments was in the early 1990s. And after a long period of time of advocacy, amendments to the guardianship statute in Pennsylvania were passed by the General Assembly in Pennsylvania and signed into law by the governor in December of 2023. So we now have a new act in Pennsylvania that's called Act 61 of 2023, and it makes amendments to the existing guardianship law. And so I wanted to talk about that. It's going to go into effect in June of this year, and it does several really important and I think transformative things for guardianship. The first is it establishes the right to counsel for people who are facing a guardianship petition in all cases. So if a guardianship petition is filed, regardless of who files it, if it's a family member, a parent, if it's an agency, whatever it is, nursing facility, whatever, the person with a disability that is subject to the petition is going to be appointed a lawyer to represent them. And the law is very clear that that lawyer has to operate like a lawyer. And what I mean by that is that they have to be a zealous advocate for the person with a disability, that they're going to challenge the guardianship petition, right? It's going to be a real hearing in front of the court with evidence, and the lawyer has to be a zealous advocate for the person with a disability and is required to carry out the express wishes of that person. So if the person with a disability says, I don't want to have a guardian, I don't want my uncle to be my guardian, whatever the express wishes of that person are, the lawyer has to advocate for that in court. It's not up to this point. A lot of times the lawyers in these cases worked around the concept of what's in the best interests of the person with a disability. And sometimes there would be agreements to enter guardianship orders for people. And that is not going to be the standard anymore with Act 61 in 2020 when it goes into effect in 2024. So that's really a big change. So if folks are contemplating guardianship or maybe gone through the process before, it's going to be different, I think, coming in June in terms of, it's going to be more of a robust process in order for guardianship proceedings to move forward. Another thing that Act 61 does is it has a big focus on these lesser restrictive alternatives that we've been talking about, supported decision-making and substitute decision-making. That in the petition, those things have to be listed, like were these things tried for a person with a disability, and if they didn't work, why not? You have to specifically say. And then the court in making a decision has to have specific findings on those things. And there's a list of lesser restrictive alternatives, all the things that we've talked about tonight that are in the law, that the court's going to have to go through those one at a time and make a decision about whether or not they would work and whether the team tried to do that, et cetera. And so these things are really important, and they're really going to be even more important in the coming months and years as this law goes into effect. Um, and the last thing that Act 61 does is around certification of guardians. So not the attorneys who are representing, but if a guardian is appointed. So if you are a person or an organization that has 3 or more wards or people under guardianship that you're the guardian for, you're going to be required to go through a certification process. And the Supreme Court of Pennsylvania is going to develop the rules around that, about what certification looks like, but that is coming soon. We can go to the next slide. I put on here some guardianship drawbacks. Again, if you're considering it, in addition to, it may not be necessary, it may be overly restrictive for the person with a disability than what is necessary. But on top of that, there are financial and administrative costs to proceeding towards guardianship. And I think particularly with Act 61 going into effect, where it's going to require more court time, more lawyer times, the process is going to be more robust, hopefully. So that's going to take more time and resources for that. And also, guardians are obligated to file annual reports, and there are filing fees for that. And the courts really, under some recent changes to the rules, are really cracking down. They're really supposed to crack down on the filing of those annual reports. So that's really going to be a mandatory thing that guardians have to do every year. Also, guardianship sometimes can cause divisions between you and other people in the family. Sometimes, we have situations where people are fighting over who should be the guardian, things like that. Another drawback to this process that may not be needed. And then finally, if a person with a disability is subject to a guardianship, unless that guardianship is reviewed and lifted, um, you really have to think of the idea of a successor guardian, because if the guardian who's appointed, let's say, passes away or no longer can fulfill the role, then the guardianship doesn't end. The court will appoint someone else to be the guardian. So those another factor that you really have to think about when you're thinking about doing this planning around decision making. Um, Next slide. Um, for folks out there, if there are people with disabilities on the call who are listening or maybe watching on the tape, some ways to advocate for yourself for control in decision making. Run your own meetings, whether it's your IEP meeting at school, if it's your ISP meeting. Participate, go to your meetings. Decisions are being made about you. Be present, run your own meeting, and speak up and be part. That's part of exercising rights and responsibilities, being a contributing citizen. Everybody in Pennsylvania can vote if you're 18 years old and you're registered. So that's something you can do to exercise your decision-making skills, become an advocate for yourself, join a self-advocacy group, and look for opportunities to learn more about decision-making. There are some really great webinars out there about that. There's some great things that PATF has done on financial decision-making for people with disabilities that are really great, and that's a good way to exercise that muscle. Next slide. Contact information for us. There's our intake line. We have live intake during the day, every day except for Wednesday. We're closed on Wednesday now, because we have so many calls that we have to work on. But you can get somebody live on the phone. And again, you can get into our system if you have questions. Someone will call you back and can talk through your specific situation. Our website is there. We have a ton of resources on this topic, as well as all kinds of other disability rights topics that are there free for you to click on and download. So you might want to check that out. I think that's it. Next slide is just questions. And
There was a chat question that came into the chat, and then I
great.
added resources and it got bumped up. But Christina
Okay.
says, if someone comes to you and says they want to revoke guardianship, where should we refer them?
Yeah. So You can always call us, and we can sometimes, not necessarily that we're going to be the one to be able to help with that, but maybe. But we can also kind of review the individual situation and give some like more specific referrals. When Act 61 goes into effect in June, and I didn't really, it was on the list, but I didn't really talk about it, so I was flying through. There are some kind of improved rules around review hearings. So it says any interested party can request a review hearing. So you could request of the court that you want to come in and have another look at whether or not the guardianship should be in place or not. Or if it's a really extensive guardianship over every area of the person's life, if it can't be revoked, maybe it can be tailored and reduced, right, to provide that person with some autonomy over certain areas. So I would say probably your first stop, if you want, is to call us, and then we can go from there with more specific advice.
Awesome. There was one more question. Yes, I will share the slides, and I'll send out a follow-up email next week with the slides and all of the links to make sure all of you have everything. Steph had a question. I don't know if you can see it.
Yeah.
Kelly, okay.
I'll go ahead and read it. My lifelong friend's mother just passed away, and she was his guardian. He's now in a group home who is acting as his payee, and me and two others will attempt to gain medical POA this month, which seems most important. He has capacity, and we have established as his shared decision team. Does he need a successor guardian? Hope not. So, um, yeah, I agree. It sounds like from what you've described, he doesn't need to have a guardian. I think the problem is that he still is officially under a guardianship order, because that's the thing about guardianship is it's particularly for people who are people with developmental disabilities who have lifelong disabilities and may go under guardianship when they're at a young age. Like, it's there, it just doesn't stop. People that are elderly and maybe they have Alzheimer's or dementia, and it's, at the end of their life and they pass away, right? And for people with disabilities like we're talking about here, it can be there for the rest of their lives. So I would say, Steph, if you want to call us, we can talk about options. I think your plan of what you want to do sounds great, but you might need to do something about the fact that he is officially under a guardianship order with the court, even though the guardian passed away. Um, yeah, and so Steph, that's your follow-up question, yeah, which I think I answered. Danielle says, could you provide guidance as to where an individual and their family should go to seek guidance for guardianship transfer between counties? Yeah, you can call us about that. I don't know it off the top of my head, but that doesn't mean that there aren't people in my office who will be able to answer it for you, or we can look it up and we can help you with that if you want to call. That would be fine. Looks like that's the end of the questions.
Yep, I was just double checking to make sure that
Yeah.
I didn't
And
bump any out of order or anything
yeah.
strange.
Yeah, if you didn't get a chance to ask your question or you'd rather not do it in the context of this setting, please feel free to reach out. You can even say you participated in this training,
Absolutely.
and it'll get directed to me, and I'll be able to answer, and I can email you back or call you or whatever. I'm happy to do that if people have questions that they didn't get a chance to ask, or yeah, would rather not.
Absolutely. And I'll share my slides with Achiva's contact information. I'll share Kelly's slides with her contact information. That probably won't happen till Monday or Tuesday because we are leaving in the morning to take my son to the Baltimore National Aquarium. But I promise
Oh,
by
fun.
Tuesday at the latest, you will have everything. But if you think of something, a week from now, a month from now, 6 months from now, don't hesitate to reach out. I'm happy to help. connect with anything, resources, Kelly's happy to do that too. Whatever you guys need, we want to make sure that you all feel supported. So I just want to, in closing, say thank you to Kelly for being here. I know it's in the evening, and I appreciate it.
Okay.
But thank you to everyone else for being here too, because these conversations need to happen often with a lot of people, diverse people, all coming together and having these conversations. So I just wanted to thank all of you for your time and for your questions. They were fantastic. And yeah, I will be in touch with follow-up information. And if you guys need anything, let us know.
Great. Thanks, everybody.
Thank you. Have a great evening, and let us know.
Great. Thanks, everybody.
Thank you. Have a great evening.
Have a great evening. Bye-bye.